Okay, tuloy pa rin tayo sa ating pagbabasa ng Mercantile Law. Andito na tayo sa Intellectual Property Code. Ayan na, Intellectual Property Code. Okay, so ano naman ang mga patentable inventions? Kasi sa inventions, dalawa yan eh. Merong patentable, merong non-patentable. So ang patentable inventions under the Intellectual Property Code are any technical solution, ulitin natin, any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable shall be patentable. Ayan. So any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable shall be patentable. Ano naman yung mga non-patentable inventions? Non-patentable na mga bagay-bagay. Number 1, discoveries, scientific theories, math methods. Number 2, schemes, rules, and methods of performing mental acts, games, business, and programs for computers. Number 3, methods for treatment of human or animal body. Number 4, plant varieties and animal breeds. Number 5, aesthetic creations. Number 6, anything which is contrary to public order or morality. Yung lahat ng yon shall be non-patentable. Right to patent. Yan. Right to patent belongs to the inventor, is his heirs, or assigns. When two or more persons have jointly made an invention, the right to a patent shall belong to them jointly. Ayan. So yung right to patent belongs to the inventor, tagapagmana niya, assigns, tapos kung sakali naman dalawa sila na jointly made an invention, the right to patent shall belong to them jointly. Ano naman ang first to file rule? Shall belong to the first person to file an application. Yan. Two or more persons created the same invention separately and independently. So meron parehong-pareho kayo na nagawa. Invention 'yon. Yung right to patent shall belong to the person na who will first file an application for patent. Ano naman yung mga grounds for cancellation of patent? Okay. Number 1, what is claimed as an invention is not patentable. Okay, hindi naman pala patentable. Non-patentable naman pala yung sinasabi mong invention. Number 2, patent does not disclose the invention in a manner sufficiently clear and complete for it to be carried out by any person skilled in act. Okay, so siguro pwede nating masabi yun yung hindi siya industrially applicable. Number 3, contrary to public order and morality. And number 4, patent includes matters outside the scope of the disclosure contained in the application as filed. So yun ang grounds for cancellation of patent. The Intellectual Property Code provides that the following constitute patent infringement. So, ito yun. Patent infringement, parang ang dating ay krimen, ano? Parang ganun. Making, using, offering for sale, selling, or importing a patented product or a product directly or indirectly obtained from a patented process. At saka, using a patented process without authorization of the patent owner. So, ang tawag doon ay paglabag sa Intellectual Property Code. Yan, it constitutes patent infringement. Diba? Okay. Ano pa? Nasa na tayo? Okay, on a side note, meron tayong nakita rito na dominancy test na ang nangingibabaw rito. Inabandona na yung holistic test. So, dominancy test na under the patent law yung ginagamit. Okay, saka natin pag-aralan yung dominancy test. Sandali, maghanap-hanap tayo ng kahulugan ng dominancy test sa internet. Okay, dati kasi ginagamit yung ina-apply yung holistic test. Pero di ba kakasabi lang natin, wala na yon as of now. as of 2022 na binabasa ko to. So para lang malaman natin, holistic test requires that the entirety of the marks in question be considered in resolving confusing similarity. Pero yung dominancy test focuses on the similarity of the prevalent features of the competing marks. Ito ayon nga sa jurisprudence, no? In USA Incorporated versus Inter-Pacific Industrial Trading Corporation, sabi ng ating Korte Suprema, in determining similarity and likelihood of confusion, jurisprudence has developed tests, yung dominancy test and holistic o yung totality. So, ang ginagamit na yata ngayon, di ako nagkakamali, ay yung dominancy test. The dominancy test focuses on the similarity of the prevalent or dominant features of the competing trademarks that might cause confusion, mistake, and deception in the mind of the purchasing public. Okay. Duplication or imitation is not necessary. Neither is it required that the mark sought to be registered suggests an effort to imitate. Given more consideration are the aural and visual impressions created by the marks on the buyers of goods, giving little weight to factors like prices, quality, sales, outlets, and market segments. Okay, yun yung sinasabi ng Korte Suprema. Hindi ko pala na-i-pause ang haba natin. Ulitin natin, dominancy test focuses on the similarity of the prevalent or dominant features of the competing trademarks that might cause confusion, mistake, and deception in the mind of the purchasing public. Okay, yun yung sinasabi ng ating Korte Suprema. Okay, ano naman ang ibig sabihin ng mark? Mark means any visible sign capable of distinguishing the goods, a trademark, or services, service mark, of an enterprise and shall include a stamped or marked container of goods. Yun ang mark. Ano naman ang collective mark? Collective mark means any visible sign designated as such in the application for registration and capable of distinguishing the origin or any other common characteristics, including the quality of goods or services of different enterprises which use the sign under the control of the registered owner of the collective mark. Okay, so mark, any visible sign capable of distinguishing the goods. Collective mark means any visible sign designated as such in the application for registration and capable of distinguishing the origin or any other common characteristics, including the quality of goods or services of different enterprises which use the sign under the control of the registered owner of the collective mark. So under the Philippine Intellectual Property Code, rights to a trademark are acquired through registration with the Bureau of Trademarks of the Intellectual Property Office. Diba napag-usapan natin kanina yung first to file rule. Unang makapag-file ng application ay siyang kung dalawa, parehas kayo nakagawa ng parehong materyales, parehong invention, yung una mag-file ang siya mangingibabaw. Kasi nga yung trademark is acquired through registration with the Bureau of Trademarks of the Intellectual Property Office. Generally, protection against infringement is accorded only to marks duly registered with the Intellectual Property Office. Also, priority of rights in a trademark is not anymore based on prior actual use, but on prior filing of an application for registration. Dati kasi, ginagamit yung holistic test. Ngayon, mas kinakatigan ng Korte Suprema yung dominancy test. Dati, prior actual use. Ngayon, prior filing of application for registration. Sino unang nag-file ng application. Under the Philippine Intellectual Property Code, a well-known mark, a well-known mark is protected against reproductions, translations, and confusingly similar marks even if it is not registered in the Philippines. It extends even to unrelated goods and services. Okay. Elements of trademark infringement. Number 1, a registered trademark in the Philippines. Number 2, plaintiff's ownership of said mark. And number 3, use of the trademark or imitation thereof by a third person which results in likelihood of confusion. So yun ang mga elemento ng trademark infringement. Ano naman ang unfair competition? Unfair competition is a form of copying and making false statements by one who passes off his own goods for those of another that has an established goodwill. The copying or passing off may include copying of the trademark or giving one's own goods the general appearance of another which causes likelihood of confusion. Ano yung elemento ng unfair competition? Elements of unfair competition. Number 1, confusing similarity in the appearance of goods involved. And number 2, intent to deceive the public and defraud competitor. Siguro ang isang naiisip ko dyan, yung mga kalokohan dati na it is meant as a joke, pero kunwari yung sign na McDonald's, yun ang sign, yung letter M, yung mark, parehong-pareho, tapos nakalagay McDonald Eatery. Yun, I think, pinagbabawal yun. Pero dati, siguro 10 years ago, nauso yun sa internet na as a joke. Okay. Okay, magtungo naman tayo sa copyrights. Under pa rin ito ng Intellectual Property Office, no, yung copyright. On a side note, ang sabi, copyright during his lifetime and 50 years from his death. Yung 50 years from his death magsisimula in first day of January after his death. So kung si Pedro namatay siya ng 2010, December 2010, January 2011, first day of January 2011 magsisimula yung pagbibilang mo ng 50 years na meron pa siyang karapatan doon sa copyright na yon. Okay? Yun daw ang copyright. 50 years from his death. 50 years from the first day of January after his death. Yan, para mas eksakto tayo. Okay, ano naman ang copyrightable works? Ano-ano ang mga copyrightable works under the Intellectual Property Code? No? Ito yung mga novels, poems, plays, reference works, newspapers, advertisements, computer programs, databases, films, musical compositions, choreography, paintings, drawings, photographs, sculpture, architecture, maps, and technical drawings. So, ano naman ang doctrine of fair use? Ginagamit yan sa usapin ng copyright. Doctrine of fair use. Fair use of a copyrighted work for criticism, comment, news, reporting, teaching, including multiple copies for classroom use, scholarship, research, and similar purposes is not an infringement of copyright dahil yung mga nabanggit natin na yun are non-copyrightable. Under the Intellectual Property Law of the Philippines, copyright protection for artistic, literary, and derivative works lasts during the lifetime of the author plus 50 years after the first day of January immediately preceding the author's death. This term of protection also applies to posthumous works. So ito yung limitations ng copyright, no? 50 years lang after the first day of January ng immediately preceding the death of the author. Rights of copyright owner. Ano na yung mga karapatan ng copyright owner? Number 1, right of reproduction. Number 2, right to distribute. Number 3, right to make derivative works. Number 4, right to publicly perform. Number 5, right to follow. Number 6, right to paternity. Number 7, sui generis rights. And number 8, private copying. Ano naman ang copyright infringement? Ito, pinakasikat na naririnig natin to. Like sa YouTube, pag kunwari, nag-upload ako, dati nang meron ako radio program, meron akong background music, ilalagay ko, no copyright infringement intended. So, pero walang epekto sa YouTube kasi kung hindi mo music, may copyright claim, matik. Okay, what is copyright infringement? Copyright infringement occurs when there is a violation of any of the exclusive economic violation of any of the exclusive economic or moral rights granted to the copyright owner. It may also consist in aiding of abetting such infringement. Okay, so yun ang copyright infringement. Okay, magtungo na tayo sa fifth major topic natin ng Mercantile Law, yung Anti-Money Laundering Act, RA 9160 as amended. Anti-Money Laundering Act. Okay, so ano-ano yung mga covered institutions? Okay. Covered institutions. Number 1, banks, non-banks, quasi-banks, trust entities, and all other institutions and their subsidiaries and affiliates supervised or regulated by the BSP. Number 2, insurance companies and all other institutions supervised or regulated by the Insurance Commission. Number 3, securities dealers, brokers, salesmen, investment houses, and other similar entities managing securities or rendering services as investment agent, advisor, or consultant. Under number 3 pa rin, mutual funds, closed-end investment companies, common trust funds, pre-need companies, and other similar entities. Under number 3 pa rin, foreign exchange corporations, money changers, money payment remittance, and transfer companies, and other similar entities. And under number 3 pa rin to, mga subtitle 4, no? Other entities administering or otherwise dealing in currency, commodities, or financial derivatives based thereon, valuable objects, cash substitutes, and other similar monetary instruments or property supervised or regulated by the Securities and Exchange Commission. So those are the covered institutions of the Anti-Money Laundering Act. Itong mga nabanggit nating covered institutions has the duty to report a covered transaction in cash, total amount in excess of 500,000 within one banking day. So covered transaction yon pagka in total amount lumagpas ng 500,000 pesos within one banking day. So yun ang covered transaction nila. Total amount in excess of 500. Kunwari nag-deposit ka ng 501,000 within one banking day. So yun ang covered transaction. Duty yun i-report nitong mga nabanggit natin na covered institutions. At duty rin nilang i-report yung tinatawag na suspicious transaction regardless of amount. Suspicious transaction i-report din nila. Kailan ba nagkakaroon ng suspicious transaction? When there is no legal or trade, there is no there is no legal or trade obligation, purpose, or economic justification. Amount is not commensurate with the financial capacity or business. It is related to unlawful act. Transaction is structured to avoid reporting. Yung parang kahina-hinala, no? And all other analogous circumstances. So, covered institutions, yung mga bangko, insurance companies, mga other entities administering currency commodities, they have, it is their duty, lawful duty to report covered transactions. Ito yung mga cash deposits siguro or withdrawal. I don't know kung kasali yung withdrawal. Basta covered transaction in cash, total amount in excess of 500,000 within one banking day, and to report suspicious transactions. Okay. Nasaan na tayo? Okay. AMLA pa rin. Anti-Money Laundering Act pa rin. Ano yung safe harbor provision? Safe harbor provision. No administrative, criminal, or civil proceedings shall lie against any person for having made a covered transaction report in the regular performance of his duties and in good faith, whether or not such reporting results in any criminal prosecution under the AMLA or any other Philippine law. So yun ang safe harbor provision ng Anti-Money Laundering Act. Bas nag-report ka ng wala namang bad faith, in good faith naman. Sa tingin mo kahina-hinala, ni-report mo yung suspicious transaction o dili naman kaya ni-report mo yung covered transaction. Kahit wala namang masama doon na napagtanto naman na legitimate business siya, legitimate person, hindi naman galing sa masama, hindi man commensurate. Kunwari, security guard ang work niya pero nag-deposit siya ng 1 million pero ipon niya pala yung buong buhay niya bilang security guard, nagsa-sideline siya na sa banda, kunwari, nagda-dancer siya. Marami siyang sidelines pala, legitimate pala. Nagkataong suspicious lang dahil feeling mo hindi commensurate na mag-deposit ang isang security guard ng 1 million sa bangko. Kahit walang prosecution na naganap, safe ka from prosecution. No administrative, criminal, or civil proceedings shall lie upon any person na ginawa niya lang naman yung trabaho niya. Okay, ano naman ibig sabihin ng money laundering? Money laundering, very popular. Money laundering. Money laundering is a crime whereby the proceeds of an unlawful activity as defined in the Anti-Money Laundering Act are transacted or attempted to be transacted to make them appear to have originated from legitimate sources. Galing sa illegal, pinasok mo sa bangko para magmukhang galing sa legal. Ano yung mga predicate crimes o yung mga unlawful activities under AMLA? Mga kidnapping for ransom, drug trafficking and related offenses, graft and corruption practices, plunder, robbery and extortion, wetting and masiyaw, piracy, qualified theft, swindling, smuggling, violations under E-Commerce Act, hijacking, destructive arson, murder including those perpetrated by terrorists, fraudulent practices and violations of Securities Regulation Code of 2000, felonies of similar nature punishable under penal laws of other countries, terrorism financing, attempt to commit terrorism financing, attempt or conspiracy to commit dealing with property or funds of designated person, accomplice to terrorism financing, accessory to terrorism financing, and other offenses such as failure to keep records by any responsible official of covered institution, and yung malicious reporting. Okay. So under the Anti-Money Laundering Act, notwithstanding the provisions of the Bank Secrecy Law, the Foreign Current Deposit Act, the General Banking Law, and other laws, the AMLA may inquire, ito yung Anti-Money Laundering Council, may inquire into or examine any particular deposit or investment with any banking institution or non-bank financial institution upon order of any competent court in cases of violation of Anti-Money Laundering Act when it has been established that there is probable cause that the deposits or investments involved are in any way related to a money laundering offense. Okay, yung AMLAC na yan yung council na nilikha ng Anti-Money Laundering Act. Okay, yung Anti-Money Laundering Council has the authority to freeze. Okay? Anti-Money Laundering Council has the authority to freeze upon determination that probable cause exists that any deposit or similar account is in any way related to an unlawful activity. The AMLAC may issue a freeze order which shall be effective immediately on the account for a period not exceeding 15 days. So nakalagay sa batas sa AMLAC na yung freeze order na yon, di ba, pwede raw nilang extend. Pero hindi siya dapat lalagpas ng 6 months. So ang freeze order hindi dapat lalagpas in any case ng 6 months. Yan ang sabi ng batas. Okay, so ulitin natin. Ang AMLA may authority to freeze, pero effective immediately yon on the account for a period not exceeding 15 days yon. At yung freeze order, extendable yan, pero in no case shall it exceed 6 months. Ayun ang sabi. Okay, magtungo na tayo sa last na act, no, under Mercantile Law. Ika-anim na, hindi pa pala, dalawa pa pala ito, hanggang 7 pala tayo. Okay, magtungo muna tayo sa number 6, na major topic ng Mercantile Law, yung Electronic Commerce Act. Electronic Commerce Act. Information shall not be denied validity or enforceability solely on the ground that it is in the form of an electronic data message purporting to give rise to such legal effect, or that it is merely incorporated by reference in that electronic data message. In any proceedings involving a secure electronic record, the court shall presume, unless contrary is proved, that the secure electronic record has not been altered since the point of time to which the secure status relates. Okay, so kailangan ng affidavit of evidence. So all matters relating to the admissibility and evidentiary weight of an electronic document may be established by an affidavit stating facts or direct personal knowledge of the affiant or based on authentic records. Okay, so kailangan merong affidavit of evidence. Ano naman yung obligation of confidentiality? Obligation of confidentiality. The access to an electronic file or an electronic signature of an electronic data message or electronic document shall only be authorized and enforced in favor of the individual or entity having a legal right. Okay. So ayon sa Electronic Commerce Act, information shall not be denied enforceability solely on the ground that it is in the form of an electronic data message. Kailangan mo lang ng affidavit of evidence, okay, and obligation of confidentiality. Okay, magtungo na tayo dito sa final. Ito na. Parang tama na ako. Final na batas na special law under yung FRIA law, no? Under Mercantile Law. So, yung Financial Rehabilitation and Insolvency Act. Yeah. Financial Rehabilitation and Insolvency Act. Ito yung FRIA law. FRIA. Okay, letter A. Basic concepts muna tayo. Number 1, ano ba ang rehabilitation? Rehabilitation refers to the restoration of the debtor to a condition of successful operation and solvency. Yan. When rehabilitation is not feasible, it is in the interest of the state to facilitate a speedy and orderly liquidation of those debtors' assets and the settlement of their obligations. So yun ang rehabilitation. Pag hindi feasible ang rehabilitation, liquidation na. Ano ba ang liquidation? Liquidation is a process by which assets are converted to cash. Ano naman ang insolvent? Number 3. Insolvent means the financial condition of a debtor that is generally unable to pay its or his liabilities as they fall due in the ordinary course of business or has liabilities that are greater than its or his assets. Mas malaki utang kaysa sa kanyang mga pag-aari. Number 4, anong ibig sabihin ng suspension of payments? Ito, mahaba-haba ito. Suspension of payments. When a Filipino who possesses sufficient property to cover his debts but foresees the impossibility of meeting them when they respectively fall due, he may file a verified petition that he be declared in the state of suspension of payments with a special commercial court in the province or city in which he has resided for 6 months prior to the filing. So, ano to? Verified petition ng isang tao na isuspend yung payment niya. Ayun. Sapat naman yung kanyang pag-aari para bayaran niya yung mga utang niya. Kaso, baka hindi niya ma-meet. Hindi niya pa naibenta yung ari niya. Hindi pa siya liquid, no? So, the court finds sufficiency in form. Nag-file ka ng verified petition mo. If the court finds sufficiency in form and substance, mag-i-issue yung court ng order within 5 working days, calling a meeting of all the creditors. Okay. I-direct niya rin yung publication of order. Okay. So si court yan ha. Magpapatawag siya ng meeting of all the creditors. Okay. Tapos ipapublish ng korte yung order nila. Yung creditors naman submits written evidence of claims. Yan yung susunod na mangyayari. Ano ba yung ebidensya nila ng kanilang claim? Susunod na mangyayari, magsisend ng order to creditors forbidding debt, sends order to creditors, magsisend yung court ng order na sinasabi niya sa creditors na, oops, pinagbabawalan ko yung debtor na ibenta niya yung pag-aari niya. Okay. Tapos yung korte the court shall prohibit the debtor from making individual payments except yung mga bayarin na necessary, legitimate expenses, gasolina ng kotse mo, pagkain mo, yung mga ganyan. And then the court shall appoint a commissioner to preside over creditors meeting. Meron nang itatalaga yung korte na commissioner na siyang magpe-preside over creditors meetings. No creditor shall sue or institute proceedings to claim payments for as long as proceedings remain. Okay, so pag merong taong may utang sa'yo, tapos pinatawag ka niya ng korte, in a case of merong nag-file yung may utang sa'yo ng suspension of payments, wag ka na munang, wala kang karapatan ayon sa batas, ayon sa FRIA law, na mag-institute ng other claims kasi inaayos nga, di ba? If the decision of majority of creditors is approved by the court, nagkasundo yung mga pinagkakautangan, mga creditors. If the decision of majority of creditors is approved by the court shall order that the agreement be carved out and all parties bound thereby to comply with its terms. Okay. Yan yung suspension of payments. So, pwede palang mag-file ng verified petition for suspension of payments. So, yan yung basic concepts under FRIA law, Financial Rehabilitation and Insolvency Act. Yan. Okay, magtungo naman tayo sa usapin na modes of rehabilitation. Under FRIA, under FRIA law pa rin ito ha. FRIA law, okay. So, okay. Una, yung court-supervised rehabilitation. Dalawa pala yan, ano? Modes of rehabilitation, court-supervised and pre-negotiated rehabilitation. At tatlo pala. And out-of-court or informal restructuring agreement or rehabilitation plan. So, tatlo ang modes. Court-supervised, pre-negotiated rehabilitation, and out-of-court or informal restructuring agreement of rehabilitation plan. So under court-supervised rehabilitation may dalawa, voluntary liquidation and involuntary liquidation. So under voluntary liquidation, a Filipino whose properties are not sufficient to cover his liabilities and owes debts exceeding 500,000 pesos may apply to be discharged from them by filing a verified petition with the Special Commercial Court. So, same process siya dun sa nabanggit ko dito sa suspension of payments. Yung verified petition ng anong tawag dito? verified petition with a special commercial court. Lumagpas nga naman ng 500,000 yung utang, ano? And letter B under court supervised rehabilitation, yung involuntary liquidation. Okay. Pag involuntary liquidation naman, yung mga creditors, yung mga pinag-uutangan naman ang nag-file ng verified petition with a special commercial court na sandali, hindi sufficient yung pag-aari ng may utang sa amin to cover his liabilities. Okay. So, commencement order. Ano yung commencement order? In court-supervised rehabilitation proceedings, the court examines the petition to determine if it is sufficient in form and substance. Yan. If the petition is sufficient, the court proceeds to issue a commencement order. Okay. Ano naman yung stay or suspension order? Stay or suspension order refers to an order in conjunction with the commencement order that shall. So this order is a conjunction with the commencement order that shall, letter A, suspend all actions or proceedings in court or otherwise for the enforcement of claims against the debtor. Letter B, suspend all actions to enforce any judgment, attachment, or other provisional remedies against the debtor. Letter C, prohibit the debtor from selling, encumbering, transferring, or disposing properties. And letter D, prohibit debtor from payment of liabilities outstanding except in the ordinary course of business. So, similar siya doon sa binasa natin kanina doon sa petition for suspension of payments. Ano? Okay, so yun ang involuntary liquidation and voluntary liquidation under court-supervised rehabilitation. Ikalawang mode naman ng rehabilitation, yung pre-negotiated rehabilitation. Pre-negotiated rehabilitation. So the proceeding involves the confirmation of the court of a rehabilitation plan that was already pre-negotiated by the debtor and its creditor. So meron kayong plan. Di ba? Parang yung binasa natin kanina, di ba, pag merger, may plan of merger. Di ba? Meron din palang rehabilitation plan. Okay. Rehabilitation plan is already pre-negotiated by the debtor and its creditors. So a petition may be filed by the debtor or jointly with its creditors. Ito yung nagkakasundo-sundo sila sa plano na para gusto ng debtor magbayad, gusto rin ng debtor tulungan siya na makapagbayad, no? So itong rehabilitation plan na ito refers to a plan by which the financial well-being and viability of an insolvent debtor can be restored using various means including but not limited to debt forgiveness, debt rescheduling, reorganization, quasi-reorganization, dación en pago. Ito yung the delivery and transmission of ownership of a thing by the debtor to the creditor as an accepted equivalent of the performance of an existing obligation. Kunwari may utang akong 501,000 tapos meron ako mga chairs worth 501,000. Yun. Dación en pago, yun ang ipinambayad ko. So ano pa ba? Wait lang. Debt equity, yan. Debt equity conversion and sale of business or parts of it, yan. Bahagi yan ng plan, no? As a going concern or setting up new business entity, pwede rin yun. Tayo siya ng bagong negosyo. Or other similar arrangements as may be approved by the court or creditors. Yan yung pre-negotiated rehabilitation. And last mode of rehabilitation under the FRIA law, Financial Rehabilitation and Insolvency Act. Last mode of rehabilitation is yung out-of-court or informal restructuring agreement for rehabilitation plan. Out-of-court or informal restructuring agreement or rehabilitation plan. Ano yung minimum requirements dito? Debtor agrees, no? Tapos, approved by the creditors representing 67%. So pumayag si debtor. Inaprobahan ng creditors representing 67% of the secured obligations of the debtor. O dili naman kaya? Or approved by the creditors representing 75% of unsecured obligations? O dili naman kaya? Approved by creditors holding at least 85% of the total liabilities of the debtor, secured or unsecured. So yan yung out of court or informal restructuring agreement or rehabilitation plan. Yan. Okay. Ano yung standstill period? Standstill period refers to the period agreed upon the debtor and its creditors to enable them to negotiate and enter into an out-of-court or informal restructuring or workout agreement or rehabilitation plan. So that is called standstill period. Okay. May pinag-usapan na period, no? Ng yung debtor at saka yung creditors para naman makapag-negotiate sila. Makapag-areglo sila out of court kung paano mababayaran yung mga utang. Standstill period. Standstill, wala munang mag-aaway-away. Yan, parang ganun, no? Pag-usap muna tayo. Maglaan tayo ng oras para pag-usapan kung paano tayo mababayaran. Okay, and yung last topic natin naman tapos na tayo sa basic concepts, rehabilitation, liquidation, insolvent, definition, tsaka suspension of payments. At tapos na tayo sa modes of rehabilitation, yung in-court supervised, number 2, pre-negotiated, number 3, out of court. Magtungo na tayo sa liquidation, di ba? Nabasa na natin kanina yan, pahapyaw, di ba? Liquidation is a process by which assets are converted to cash. So under the jurisprudence, the Supreme Court held that when rehabilitation will not result in a better present value recovery for the creditors, the more appropriate remedy is liquidation. It allows corporations to wind up their affairs and equitably distribute its assets among its creditors. In liquidation, corporations preserve their assets in order to sell them. The proceeds of the sale are distributed equitably among creditors, and the surplus is divided or losses are reallocated. Okay, so merong voluntary liquidation at merong involuntary liquidation. Voluntary liquidation shall refer to liquidation proceedings initiated by an insolvent juridical debtor. So yung korporasyon na may utang, okay? May utang si korporasyon ang pinag-uusapan natin dito sa liquidation. Nag-initiate siya ng liquidation proceedings sa court. Ang involuntary liquidation naman, initiated by 3 or more creditors. So, pwede silang mag-initiate ng involuntary liquidation kung 3 or more ang pinagkakautangan ang creditors. So, ano naman ang liquidation order? Ito, in connection with yung pinag-uusapan natin. Liquidation order is the order issued by the court if it finds the petition for liquidation to be sufficient of form and substance within 5 working days from the filing of the petition for liquidation. So, yan yung sinasabi ng FRIA law. The liquidation order declares the debtor insolvent and orders the liquidation of the debtor, and in case of a juridical debtor, declares it as dissolved. Okay. So, kung juridical debtor ka, korporasyon, dinideklara niyang dissolved na yung corporation na yun. Kapag may liquidation order at matik daw kung juridical debtor ka, it declares it as dissolved. Anong epekto niya? Effects. Number 1, juridical debtor shall be deemed dissolved. Yung corporation, dissolved na. Number 2, legal title and control of assets shall be deemed vested in the liquidator or pending his election or appointment with the court. Court na yung may legal title and control of the assets. Number 3, all contracts of the debtor deemed terminated. Number 4, no separate action for the collection of an unsecured claim allowed. So hindi pinapayagan kung hindi naman secured yung claim mo, hindi pinapayagan yung separate action for the collection thereof. Number 5, no foreclosure proceeding shall be allowed for a period of 180 days. And number 6, authorize payments of administrative expenses as they become due. Okay, so dyan tayo nagtatapos sa ating mercantile law. Napag-usapan na natin sa bandang huli yung FRIA law. God bless you.